The suit will appear in the list for witness action on the date copy. When will you come? Next week?
Any day, your lordship, except 20th and 24th, if your lordship's diary permits. 26th or 27th, your lordship, if your lordship's diary permits.
March, I think. Witness action, any day it can come.
26th or 27th.
We have 5 days a week, so any day it can come. 27.
Correct.
Yes, Finor came.
Your Lordship, kindly may I mention one commercial division matter, Your Lordship. This matter has been settled, Your Lordship. Let it appear in the list for recording settlement, Your Lordship.
Tomorrow.
Tomorrow, Your Lordship.
Tomorrow, make it Thursday. Thursday it will come.
Grateful, Lordship.
Commercial division, item number 1.
Yes, my lord, I appear for the plaintiff. My lord, Lordship on the last occasion directed us to prepare a compilation of the exhibits. I have prepared the compilation, my lord, may I? But also give a copy.
Mr. Mitra, have you finished your argument or not? Now I have to hear him.
No, Mr. Basu. I'm the plaintiff. Mr. Mitra is for the defendant. But I will give a copy of the compilation to Mr. Mitra.
Compilation of exhibits, okay. And written notes? Written notes are...
These are exhibits.
Yes, these are the exhibits, my lord, marked in the present suit.
All right. And compilation of plain written statement, it is not there.
My lord, plaint is there, written
All
statement
right.
is there.
Not that, that's the old suit. So it's papers.
Yes.
Now the written, we have filed our written notes before the court.
All right.
Yes, I have completed my argument.
You say you start your argument today?
No, I'm calling. My lord, I'll just give your lordship the background. My lord, here, my lord, my suit is for recovery of the advance consideration that I made over to the defendant. My lord, the agreement was such that along with the defendant,
Your Finor came.
Yes. The agreement between the parties was executed on the 1st of August, 2nd of August 2019. But if lordship kindly takes the agreement first, my lord, it is that compilation. Now I will only refer to the documents in the compilation, my lord, page 14 onwards. But this is the agreement that was executed between the parties, 2nd of August 2019. My lord, if lordship sees, my lord, clause 1. My lord, kindly see this was issued to the defendant. All the pages have been accepted by the defendant and the acceptance is also endorsed in this document itself. But kindly see the first clause, your appointment with ML. Previously, the plaintiff was known as Markham Limited. That is the reason why the short form ML as a business consultant will commence on your joining ML simultaneously with joining of other experts from rubber chemical field. The aforesaid experts will be selected and recruited based on your recommendation and our approval thereof. These experts shall be absorbed in ML for the smooth running of the business, and those experts shall be absorbed as consultants or on permanent employment in the payroll of ML at not less than their current emoluments. Your appointment as above shall be valid from the date of joining of all the aforesaid experts and shall be in force for a period of 5 years unless terminated, separated earlier by either side, subject to the terms and conditions mentioned below. Now, my lord, there are two limbs, or if I, my lord, in my humble submission, if I rephrase it, that there are two parts to the first clause of the agreement of 2nd of August 2019. The first part is that it is the obligation of the defendant to recommend the appointment of experts. He has to recommend. Because lordship sees
so a recommendation is contemplated.
Yes, it was an obligation for the defendant to
recommendation is contemplated here.
Not contemplation, but it was a serious obligation of the defendant. He has to recommend. He has to recommend.
So the process, what he says,
recommend aforesaid experts
simultaneously with joining of other experts.
Yes.
First thing.
Yes.
these experts
No, if Lordship
would
says,
be recommended first,
yes,
then selected by you.
yes. So it is the recommendation that precedes my selection or approval. If there is no recommendation from
There
the
cannot be
defendant,
selection.
the other experts from the rubber chemical fields will not be inducted or selected by me. So the first obligation is of the defendant to recommend. It is only upon acceptance of the recommendation that the selection or appointment will follow. And it is
Was
only,
it accepted?
yes, but this was accepted. If Lordship sees the last page of the document, page 25. In fact, my Lordship sees
Yes,
page
accepted and
24.
declaration.
Yes,
Page?
page 24 of the compilation,
Yes.
he has given
Accepted.
a declaration. So he is well aware of the terms and conditions. So my lord, as I was saying,
Where is
No, no.
WS?
but the written statement has been is there. My lord, his case is, the defendant's case is that the four
It
rubber
goes to-
experts joined the plaintiff.
Just a minute.
That document was marked. 1 to canon. No, no, no. You can ignore it. দেখো তুমি এটা এক্সট্রা পাতা লাগিয়ে দিয়েছো, কিন্তু এটা তোমার এখানে নেই। But in the জজ সাহেবের কপি আছে।
এটা এক্সিবিট কপিতে নেই।
হ্যাঁ, it will must be there.
এই এক্সিবিট ডিটা দেখি।
Exhibit D.
তুমি এখানে লিস্টে এক্সিবিট 1 এক্সিবিট
Why Exhibit 1 was not marked?
100% list. List of 85. Exhibit 2 is 88. Yeah, mark it.
Yes.
Yes. So, my lord, if I, as I was saying, so it is the recommendation which is the first obligation. Only upon acceptance of the recommendation that the selection will follow. Now, my lord, the next stage of the selection is the appointment of those four experts. Only when these four experts are appointed pursuant to the recommendation made by the defendant, that the appointment of the defendant will be valid or else not. Because Lordship will see, the first clause of the agreement itself says that your appointment as above shall be valid from the date of joining of all the aforesaid experts and shall be in force for a period of 5 years. So if we, my lord, if we see the chronology of events, number 1 is his recommendation, thereafter my approval, and number 3 is the date of joining. Until unless all item number 1, 2 and 3 are complied with or, my lord, completed, only then the appointment of the defendant in the plaintiff company will be considered to be valid, or else his appointment is invalid. Now, my lord, be that as it may, my lord, he represented that he will bring in all those four rubber experts. In that context, my lord, advance payments were made to him. Later on, my lord, we saw or we realized that, my lord, the other four rubber experts did not join the plaintiff. Hence, my lord, in terms of clause 1, since those rubber experts did not join, my lord, his appointment was rendered invalid, and we have filed this present suit for recovery of the advance consideration given to the defendant. Now, it is the defendant's case that, my lord, the all four rubber experts joined the plaintiff company. In fact, it was the evidence of the witness itself, the defendant, that all four rubber experts joined the plaintiff. But when he was cross-examined, my lord, he could not identify any document on the basis whereof he would have been able to corroborate or demonstrate that 4 rubber experts joined in terms of clause 1 of this agreement. There is no document on record. There is no document on record that would satisfy or, my lord, corroborate the oral evidence of the defendant that 4 rubber experts joined in terms of clause 1. If the 4 rubber experts did not join the plaintiff in terms of clause 1, then, my lord, the appointment is invalid. And if the appointment is invalid, then, my lord, the consideration advance that was given to him, my lord, I am entitled to refund. If lordship now sees, my lord, the other documents, my lord. Yes. Now, my lord, the second defense of the defendant is, throughout his evidence, my lord, the defendant deposed that, my lord, he was unaware of the persons concerned as to whom he should recommend. It was his evidence that he does not know who were the persons who were experts in this rubber chemical field who will be recommended, and on the recommendation I will approve, and thereafter his selection and appointment will follow. But, my lord, before the agreement that was executed on 2nd of August, my lord, the plaintiff made over a draft agreement to the defendant for his perusal. Now, my lord, the draft agreement contains an annexure where the names of all the aforesaid experts were tabulated. That document, your lordship will find, my lord, this is Exhibit A and Exhibit B, which starts from page 2 of the compilation. Kindly see page 2, this is Exhibit B. My lord, this is the draft agreement, 30th of July 2019. And lordship will kindly come to, my lord, the annexure, which lordship will find at, my lord, page 12 of the compilation. Annexure 1 of the draft agreement of 1st of August 2019. I'm sorry, 30th July 2019.
Yes.
Yes, kindly see Annexure 1, name of the individuals as mentioned in para 1 of the agreement. Now, lordship will kindly see paragraph 1 of the draft agreement, which starts at page 2.
So they are recommended.
No, my lord, they have not recommended.
Then why their name figures here?
Well, this was the draft that was sent to the defendant for the defendant to be informed that these are the rubber experts whom, my lord, these are the experts who are in the rubber chemical field whom the defendant should recommend for appointment in the plaintiff. Defendant's case is that
So this is a list of persons from whom the recommendation is to be made.
to whom recommendation was to be made, to whom the recommendation was supposed to be made by the defendant.
Where is reference to this annexure of to this?
Yes, kindly see paragraph 1, page 2 of the compilation.
Paragraph 1 is recommendations. But is there anything that this recommendation should be confined from this table?
No, my lordship sees paragraph 1. My lord, your appointment with ML as a business consultant will commence on your joining ML. Immediately after joining of such individuals in ML as mentioned is Annexure 1 given below. Your appointment as above shall be valid from the date of joining of all individuals mentioned in Annexure 1 and shall be in force for a period of 5 years unless
No, your
terminated
appointment in ML as a business consultant will commence on your joining ML immediately after joining of such individuals.
in ML as mentioned in Annexure 1 given herein below. So it is only upon joining of those persons whose names appear at page 12 that, my lord, the defendant's appointment in the plaintiff will be valid.
Now this recommendation point is not in this draft agreement. Possibly it was incorporated later.
Yes, it was incorporated later. But, my lord, the very purpose, the reason why I am showing your lordship the draft agreement is because in the written statement, a defense has been indicated that the defendant was unaware of the persons to whom my lord, my lord, whose appointment should be recommended by the defendant. The defense is that the defendant was unaware of persons involved in the rubber chemical field. The defendant was unaware of the names of the experts. So when I make over the draft agreement, my lord, indicating the names of the rubber experts, my lord, it was the obligation of the defendant to forthwith, my lord, recommend their appointment. And not only that, my lord, even if I keep aside, my lord,
So it can be taken that a list of experts were provided in terms of the draft agreement or in the draft agreement, which is not in the final agreement,
Yes, it
signed
is.
agreement.
Yes, it is not there in the. But well, this was for information of the defendant. This was for the information of the defendant that there are 7 persons who are experts in this particular field whom the defendant should recommend, and only after approval given by the plaintiff that the
Now,
defendant.
after this draft agreement was sent to the defendant,
Yes,
what was his reaction?
Malad, what the defendant did was, Malad, the defendant had forwarded a modified agreement.
Where is that?
Malad, that is Malad. That is Malad there in the yes, 31st. Yes, that is there Malad in the judge's brief of documents, page 13.
That is exhibit?
But that has not been marked as an exhibit.
Then how can I look into that?
Very well. The defendant Malad sends an email, but Malad, this document at Malad, exhibit 1, which is at exhibit A, which is at page 1, Malad, this document was sent to the defendant. It was received by him. Now, Malad, the final agreement that was executed between the parties, and even before that, if Lordship.
Silent about the names of these specialists.
Yes, but Malad, before that, if Lordship sees exhibit C, page 13 of the compilation. Exhibit C, page 13 of the compilation. Malad, this is an email which was issued by the plaintiff to the defendant immediately a day before execution of the agreement of 2nd of August 2019. The email is 1st of August 2019. Malad, kindly see, this was written by the plaintiff to Mr. Thomas. Your modified version came like a jolt to me as I thought that we have reached and concluded amicably on final payments. That your, this is very important, that your full team, as mentioned in the annexure, will join simultaneously was a precondition of our discussions and naturally not negotiable. But I am on page 13 of the compilation.
Yes, I have seen.
Yes, but I inform him specifically that his joining on the plaintiff will only be upon the joining of the other 4 experts in the rubber chemical field. That is the reason why the language used in the email, as it was a precondition of our discussions and naturally not negotiable. So this was a very important term of the agreement, that the defendant will only be inducted and his appointment will be valid upon the joining of other 4 experts in the plaintiff company.
Dr. Balan's name does not figure in this list. Annexure 1.
Annexure 1.
But Mr. Valera's name is there?
Yes.
In this Annexure 1?
No, Mr. Balan is there. Malad, if Lordship sees page 12, the first name, Dr. Jaya Balan Lakmanan, he is Mr. Balan. His name has been shortly referred as Dr. Balan.
How many experts are to be approved?
4.
So when these 2 persons put the signature as a witness in this agreement, they are
Yes.
deemed to be recommended, we can say.
No,
This
no,
is
Malad,
understanding between the parties that these persons are to be recommended.
no, Malad, the signature appearing on the agreement of 2nd of August.
These are blank.
Malad, Lordship is looking at page, Malad.
25.
That page is not there.
Yes, Malad, I think, Malad.
In this page.
No, I think, Malad, it has gone into, Malad, Lordship can ignore page 25.
Yes. Page 25 is not in the.
Yes, by mistake it has gone in. Lordship can restrict, Malad, till page 24, which is the declaration of the defendant. In any event, page 25
if I confine myself to this agreement, that is exhibit D, there is no signature of
Any event
these two persons.
Yes, any event there is no signature. But in the exhibit, this page is not there. But
No, my lord, the exhibit D contains the signature of the plaintiff, managing director,
Now,
Mr.
Mr. Bose, look, what is written here is that precondition of the discussion, naturally not negotiable. If you think it is not legal, we can delete. But in that case, I must insist both Dr. Balan and Mr. Valera.
must sign the agreement
So,
as witness and
rather
the
it will
term.
support your argument that since these two signatures are not there, so it is accepted the list and the first clause 1 was accepted.
Yes, they did
Could
not
you-
sign the agreement.
Could you follow me?
Yes, yes.
Here it is written, first, this clause 1 will be there.
Yes,
If you think it is not legal, agreement will be signed by these two persons,
yes,
named two persons.
yes.
These named two persons did not sign.
Did not sign.
That means the first term stands. That is, clause 1 is accepted.
Yes,
That is the conclusion.
yes.
Corollary. Or that can be said as deemed admission that clause 1 is acceptable.
Yes, clause 1 has been accepted. Because if Lordship sees, my lord, I must insist that both Dr. Balan and Valera must
It
sign.
is not done.
No, they did not sign.
So the previous sentence will prevail.
Yes, that your full team as mentioned in the annexure will join simultaneously was a precondition of
No,
our discussions.
If you think it
It
is
is
not
not
legal,
legal, we can delete it in the agreement, but then I must insist
it
that
is not deleted
no, it has not been deleted.
and it is not signed by these two persons.
No, it has not signed by these two persons. Now, be that as it may, my lord, the agreement of 2nd of August has been accepted by the defendant.
That is not in challenge.
That is not in challenge. My lord, the defendant has signed on each and every page of the document dated 2nd of August 2019.
Hmm.
The defendant has also accepted this fact that it is his obligation to recommend. Only upon his compliance of the obligation of recommendation that I will approve. It is only after my approval that the other 4 experts will join. If they do not join, his employment in the plaintiff will not be considered as valid. So it is his employment, my lord, depends on the achievement or upon compliance of a condition.
Yes, I understand your point. This is contingent. The appointment is contingent.
Yes, it is contingent. But if it is a contingent
That
contract,
contingency is not fulfilled, was not fulfilled.
yes. Defendant, my lord, in his defense says, and even in the oral evidence says, that those 4 experts joined the plaintiff. Now, my lord, if it is the defendant's evidence that 4 experts joined the plaintiff, my lord, it is on the defendant, my lord, to corroborate it with evidence. There is no document on record that would demonstrate or corroborate that 4 other experts joined in terms of the first clause.
Defendant's argument is rather it is independent of his appointment is independent of this clause.
No, it cannot be. It cannot be. My lord, clause 1 cannot be read in isolation. Clause 1 cannot be read in isolation because the entire agreement, my lord, proceeds on the basis that his employment.
So you have to argue 2 things. One, this clause 1 prevails, or alternatively, some other evidence to show that there was an agreement between the parties to modify or change clause 1.
Yes, in fact, my lord, there is a document. There is no document on record.
There must be some collateral evidence to show that clause 1 was modified.
Clause 1 was not modified.
Is there any evidence to that?
No, there is no evidence as such. In fact, my lord, there is no cross-examination so far as the existence and or acceptance of this document is concerned. Both the parties, my lord, we are unanimous in the clauses of the agreement is concerned. But what the argument is, what Mr. Mitra has argued, is that the other 4 experts joined the defendant. His case is that the clause 1 has been complied with in its entirety. If that is the argument, then Malad, there should have been a document on record to show that 4 experts joined the plaintiff. Now kindly see, Malad, few questions, Malad, of the witness. Malad, kindly see, Malad.
Come on the next day with your notes of argument. What is the witness action? Statement of witnesses?
The depositions are already there.
Deposition.
That would be DW1.
Yes, Mr. Thomas was DW.
Yes, show me.
Yes, my lord, kindly see, my lord, few questions.
Hmm.
My lord, kindly see, my lord, the most relevant question is, my lord, kindly see question 129 of the cross-examination of DW. 129. Because, my lord, there is a document on record wherein we had asserted that the other four experts did not join the plaintiff. My lord, kindly see, shown Exhibit 8 and Exhibit I, copies whereof are appearing at page 41 and 42 of the judge's brief of documents. My lord, these are
What is
my,
the exhibit I?
my lord, if I Exhibit I is, my lord, you will find that at, my lord, page 35 of the compilation. But kindly see this letter. Page 35 is my letter of 23rd of November 2019. It is my assertion, or it is my categorical statement of this letter claiming refund because the other four experts did not join.
Claim letter.
Now, my lord, kindly see, shown Exhibit 8 and I, copies were appearing 41 and 42.
It is not disputed.
Yes,
Disputed by him.
I have
Denied.
nothing to show. The question is, Mr. Holani has said that other four experts did not join the plaintiff company. Have you disputed or denied the contents of these two documents? I have nothing to show. Now, my lord, kindly see, my lord, question 103 to 105. But kindly see 103. I am asking you, in the present suit, you have disclosed various documents. Amongst those documents, is there any document which is a letter of appointment issued by the plaintiff showing appointment of those four rubber experts? Issuance of letter of appointment and human
Did you
resources.
ask any question? Did you ask any question to the defendant that have you recommended the names?
No, I have not asked that question because it is there already in the agreement.
Pursuant to the agreement, whether any recommendation was made or not. Did you ask this question?
No, my lord, this is not there, but the other questions are there. In fact, my lord, if lordship sees the answer to question 103, issuance of letter of appointment and human resources application are not my purview. Plaintiff had its own arrangement and agreement and an exclusive agreement with the plaintiff on certain terms and documents. Now kindly see 104. Shown Exhibit 5, a copy whereof is appearing at page 63. Will I be correct if I say that this letter was issued to you by Mr. Holani and this does not corroborate that the appointment of those four experts? I deny your statement. On the contrary, this is between myself and Mr. Holani. I just enclose the bills and ask for my fees. So like, he does not answer the question. In fact, he avoids answering the question. Now, let kindly see 105. Do I take it that this document only speaks about that you have demanded from Mr. Holani, and apart from that, no other issues have been discussed in this letter? I deny the fact. This only talks about my fees. Now, my lord, kindly see question number 109. What does this, my lord, I had shown Exhibit 3D. My lord, what does this document talk about that has been handed over to you? In this letter, it is mentioned that I was trying to meet and talk to him and certain techno-commercial issues were to be discussed.
In 102, he admitted that my duty was to recommend, my role was to recommend only.
Yes. So he has to accept the obligation because during cross-examination and even in the written statement, the agreement of 2nd of August 2019 and the clauses have not been disputed. The defendant has signed on each and every page of the document, and he has given a declaration that I have accepted the terms and conditions of the 2nd August 2019 agreement. Both of us are unanimous as far as the terms and conditions of the agreement of 2nd of August 2019 is concerned. It is the defendant's case that the...
So your argument is, since this was not done, as a contingent appointment was made, contingency was not fulfilled, hence the appointment is liable to be
terminated. That is my first point, that upon non-joining of the other experts, the employment did not take effect. If the employment did not take effect, then then I am entitled to recover the advance given to him. He is not entitled to retain the advance because the agreement did not take off. The appointment was rendered invalid upon non-joining of the other experts. But this is my defense so far as the non-joining part is concerned. Second issue is, my lord, there is no document on record to corroborate the defendant's defense that the 4 experts joined the plaintiff. It is the defendant's case that 4 experts joined, but there is no document on record. The witness says that yes, they joined, but there is no document on record. And number 3 is, my lord, the defendant has claimed counterclaim to the over and above a crore. Now, my lord, the defendant's counterclaim proceeds on the basis that he has rendered consultancy services to the plaintiff. Now, my lord, if the employment agreement does not take effect to, then, my lord, his invoices are unacceptable. He was not
I got your
entitled
point.
to.
Come on the next day with your notes of argument. I'll reserve it. Or if you, Mr. Mitro, wants to give it,
5 minutes.
come on the next day.
My lord, my lord. If the notes are given early to me, so that I can get ready on the.
Your lordship will kindly keep it after a fortnight. Within 10 days, I'll give my note to Mr. Mitra and he can prepare himself.
Next day we can.
Heard Mr. Bosch in part. Adjourn to. অনেক ক্রিমিনাল আছে 7th April 7th April is okay
7th April.
or some date later on.
Any day, subject to your lordship's convenience. my lord.
He will prepare the notes. I won't have done it.
Because I can provide 5 only 5 days for arguments and witness action in the second half. If you
7th
come
of
with
April.
interlocutory application, my options are limited. So far as argument and witness actions are there, 10th.
10th. Yes, yes. No, lordship keeps it on the 10th of April.
10th.
10th April.
Grateful.
Grateful.
2 p.m.
Yes.
Okay.
Yes, Mr. Sengupta, what would you say?
Yes, Your Lordship. I have checked, Your Lordship, the dates, and Your Lordship, on the last occasion, I said, Your Lordship, the issuance of check is an admission of liability, Your Lordship, under Section 18 of the Limitation Act. I will only show the relevant dates because, Your Lordship, this entire thing is, Your Lordship, based on the limitation point. Because there is admission.
My
Your
point was that
Yes,
you say check was issued in the year 2017. That is the plaint case.
that's my plain case.
Now, Exhibit 1,
Yes.
which you have adduced evidence.
Yes, Your
Now, Exhibit 1 was allowed only for limited purpose
Lordship.
to contradict.
Lordship.
And this contradicts your point that check was issued in 2017.
Lordship.
So, if the check was issued in 2014, then the limitation ends.
Exactly. Lordship, kindly take, Your Lordship, the evidence once.
Yes, tell me.
May I just read the evidence?
PW1.
That particular letter was not at all, Your Lordship, proved. Lordship, kindly sees.
No, that was admitted and used for only corroborative
Exactly.
purpose.
Lordship, kindly sees, Your Lordship.
No right could be based on that.
I'm on that only. I'm on that. That's not my document, Your Lordship. They relied on that particular document. Lordship, kindly take question number 207.
Now, next issue, there is another issue.
I'm answering one by one. Your
Lordship.
207. Lordship, it's the cross-examination held on 13th of February 2025.
What is 26th May 2014? Exhibit 1.
That's Exhibit 1. Page 207, shown a letter dated 26th May 2014. Can you tell who has written this letter?
What is Exhibit 4? 4, there should not be, the number
No,
should,
Your Lordship, it's maybe, Your Lordship, a typographical error. It's not 4.
দেখি একটু ডকুমেন্ট গুলো দেখি এক্সিবিট গুলো
Because there is one exhibit, Your Lordship, that is Exhibit 1.
এক্সিবিট ফাইলটা দাও
চেকটা কত নম্বর এক্সিবিট দাও না লিস্ট অফ
Exhibit 26th May 2014.
check Your Lordship, is Exhibit F. Maybe, Your Lordship, it should be Exhibit F.
No, shown a letter dated 26th May 2014.
That is the date. That is the letter, Your Lordship, which is Exhibit 1. He wanted to show, Your Lordship, an affidavit in opposition, Your Lordship, in the GA.
Yes.
Now, kindly take your lordship question number 207. Shown a letter
You
dated.
have admitted this letter was written by SNG Fashions.
No, he said letter has been written by SNG Fashions. Then your lordship kindly sees page 2 is question number 208. To whom such letter was written? Messrs. Starlight Vyapar Private Limited. Now 209, very important. Can you go through such document and tell whether the closure of the bank account was known to you earlier or communicated to you earlier? Answer is no. This document is marked as Exhibit 1. So therefore, he has specifically said that this particular document has never been communicated to me and not, your lordship, that particular
There is
information was
one typographical error. It should be undisclosed document.
maybe. So therefore, if it is a contested suit, he has to prove that document by way of a contents as well as, your lordship, the signature and the postal receipts, which he could not do. He simply said, question number 209, can you go through such document
Where
and
is
tell
your application?
my application under
138. 138 or some application was filed.
lordship, kindly listen.
Possibly 138 application, 420 application.
Yes,
What?
your lordship. Kindly take, your lordship, my, that is, your lordship, judge's brief of documents, page 22.
পুরো দরকার নেই।
So kindly take paragraph 14. This is not case of a post-dated check. Para 14, your lordship, kindly sees page
Let me
26.
go through it.
Yeah, I'm sorry.
No, Mr. Ngupta,
Yes, your
look, two arguments can be made.
yes.
What I feel. First argument is that check was issued in the year 2017.
Lordship,
The veracity of that statement is challenged by Exhibit 1.
lordship,
First thing.
lordship,
Second thing, forget Exhibit 1.
lordship.
Loan was taken in the year 2011.
Lordship.
Check was issued. I'm going with your statement.
Yes.
Check was issued in the year 2017.
Lordship.
Obviously, time bar date.
Lordship.
So section 25C will come into play.
Lordship, I'm showing, that's why your Lordship, I'm showing you, Lordship, the documents itself. Lordship, kindly take, because the dates are very important, because the limitation will only save me from the dates. You kindly take once. Page 7,
Page 7 of what?
a judge's brief of documents.
Once again, judge's brief. You are referring to those acknowledgement letters.
Exactly. Because there is no cross-examination on that. Because today, if there is a defense, there is a written statement, things are different. Today, there is no defense. Because they knew you very well, they don't have any answer at all. Page 7 is the date 30th of March 2011. Admission that money has been received by them. Page 8 is 11th of July 2014. Within 3 years. Receipt. Page 8.
This is not acknowledgement in writing.
No, it's a money receipt issued by me.
Yes,
Because
not
I have
acknowledgement in writing by the defendant.
No, because the money has been received by me. It's your Lordship, the main thing is Article 1 of the Limitation Act. Because in this particular plaint, your Lordship, I have pleaded that there is a running and continuous account. And the limitation starts from the last payment.
All right, I've heard you.
And your Lordship, on the last occasion, I wanted to show certain judgments that issuance of a check is an admission of liability.
Absolutely.
Under Section 80.
Absolutely.
And today, your Lordship, I have also shown.
Even there is a judgment, section 25C is
Lordship.
presumed to be operative on issuance of the check.
Exactly.
25C means agreement to pay a time bar date. When the check is issued,
A fresh
there is
limitation
implied
starts.
agreement.
Lordship.
But whether that is applicable in this case, both
Lordship.
comes into play.
Exactly. Three things are very important. First is an undefended suit, and I've shown that particular Supreme Court judgment, your Lordship, where it shows that my plaint case and evidence will be treated because he doesn't have any defense at all.
He doesn't have any defense.
But
He
cross-examination.
cannot produce any defense, produce any document on the basis of which his defense will be based.
Lordship.
Definitely. But at the same time, he has an opportunity to challenge your veracity of the statement, of your witness,
Exactly.
of your case.
Exactly. I accept that. Very importantly, when the Exhibit 1, it should not be taken into consideration. The reason is the witness simply said that this particular letter has not been received by me. Because he has to first prove his document. He could not prove it. The person who has written the document, the contents of the documents, whether you have received the document or not. Because he simply said, no, I have not received it. It was never communicated to me. So that's why the document could not be proved. If there is a witness of the other side, if there is a written statement, things are completely different. Then I have to cross those particular hurdles. Today, what has happened? Admitted thing that he has received money. Admittedly, your Lordship, that these particular 3 receipts he could not show, or at the time of adducing evidence, he even did not make any objection. He could not prove that these particular documents are forged documents. No police complaint, nothing. Thereafter, this is not a case of a post-dated check. That the check was given to me earlier and subsequently I put the date and placed it. That is not my case. My case is that check has been issued. He has not disputed the dates. He has not disputed the issuance of the check. He has not disputed the amount.
All right. How do you?
I'll file my written notes of arguments, your Lordship, and annexing all those particular judgments, your Lordship.
I think he should not have any defense other than this one. You are rather argument.
Lordship kindly takes up Exhibit F.
Exhibit?
Check. Exhibit F, the check, at page 11 of the judge's brief of documents. Exhibit F is the check. Lordship will find it at page 11 of the judge's
Yes.
brief of documents. Now your Lordship will see,
Ink is different.
your Lordship, ink, the check is printed, save and accept the date. Lordship, the entire check is printed, save and accept the date. This date has been purposely put only for the purpose of saving limitation. Because before this, if your Lordship sees, the money receipts that my learned friend are relying upon are only signed by them. they are not acknowledged by me. There's not a single endorsement by the defendant saying that I've paid, and an NBFC receiving interest in cash. And in fact, Your Lordship, I'll show the ledgers that my learned friend is relying upon to show that there has been continuity. Lordship, those ledgers also, he says that I've printed it out in its cross, that I've printed it out and put the name and period. That is his evidence. So these money receipts, this check, deposition of this check and the ledger have only been manufactured for the purpose of saving limitation. Your Lordship, may kindly takes up question numbers 177 of the cross-examination. The money receipt which my learned friend is relying upon to extend the period of limitation, Lordship, are all cash deposits. Before this, they were receiving money through online banking. These have been manufactured solely for the purpose of saving limitation. Kindly takes up question 177 onwards. Lordship, I have asked.
Yes, that I have seen.
He says
That I
that
have
this,
seen.
there is no endorsement. My learned friend is saying that I have not put any question.
All right. Hearing is concluded. Reserve for judgment.
Lordship, there's one more point, small point, if I may. Lordship, my learned friend, Lordship, 2-3 points. I'll just sum up quickly. Your Lordship will kindly appreciate this is an NBFC lending money without any contract, written contract, admittedly. Now they plead an oral contract. There's an oral contract. Now in its evidence, it says the oral contract has not been proved, because the oral contract, as per their evidence, was entered into by one Sham Sundar Fogla. The plaint is affirmed by Uma Devi Fogla, and the evidence is being adduced by Kapil Dev Chaudhary. So the person who had actually entered into the oral contract has not even
Money was given. Suppose, even if it is oral contract,
Lordship.
there is simultaneous conduct of the parties acting on the basis of oral contract. That is enough to show there was
Very well,
contract.
Lordship. Now may I come to my second point. The NBFC, Your Lordship, has lent a sum of money without any written agreement, and Your Lordship, the date of transaction is important. This is on 31st of
RTGS
March.
is there.
Lordship, RTGS is there. I cannot deny. I cannot
Then?
deny. So this is a
Only point is limitation.
Lordship.
That's all.
Very well, Lordship. May I
We'll file
find
your
my
lordship the written notes, your lordship.
It is there.
No, your lordship. Written notes are not have.
When you file.
3 days, within 3 days, your lordship will file.
Lordship, I'll require some time, 7 days, kindly. Lordship, there's
They
one
go
more
hard
point.
in part, adjourn to making it 2 days. 2 days 18. I'm fixing it on 24
24th.
Very well.
or 25. Making it 25. 25
Okay.
for further argument. That day I will reserve it for judgment.
Yes, yes, very well. Because we have whatever the judgments, your lordship will annex.
My learned friend may kindly supply me a copy of the judgment so that
I'll
I can
give him. I'm grateful. Abhi-
Regular list,
grateful.
item number 1,
I appear for the plaintiffs.
What
Lordship, I
correction?
already, only my lord, typographical
Have you made
errors.
corrections here?
Yes, my lord,
The-
only typographical errors.
Hand it over.
Correction as to the name, spelling of a name.
Give it.
And, yes, I'll give it.
Put it for me.
Grateful.
3.
item 3,
3 Mala is my application for the contempt of the order passed by your lordship. My lord, this matter was mentioned in view of the order passed by the coordinate bench. My junior had shown this.
Item number 10 is the main matter.
Main matter is item number 10. The order was passed by your lordship on the
In item number 10.
no, item 3 has been called. Down. Item 3 has been called, which is a new application, ICC number 30 of 2025. This is an application for contempt. This was mentioned, and in view of this
CC 30.
30, here, the coordinate bench, because the original order was passed by the coordinate bench. So initially, this contempt application.
Justice
was placed-
Krishna Rao.
Yes, my lord.
Then you place the matter
No,
before.
it was placed before that. Kindly see that the order passed by the coordinate bench. After this, all the subsequent extension have been granted by this court, and his lordship has said in the order that because your lordship also has the regular determination of this testamentary suit, therefore it will be proper if the matter appears in this list.
I'm keeping it with you. Keeping with me.
Yes, yes. Now, Lordship sees the, or if the application.
How can
my
this
lord-
be? This contempt matter may be heard by me.
Yes, but all the orders have been passed by all. The original order is by Justice Rao, but thereafter, when change of determination, now that the testamentary suits have been taken by this court, all the extensions thereafter have
I
been
will check
granted
it.
by this court,
I will check it.
including a Lordship last order, because the interim order, this order which is now under contempt, the interim order is expiring on 31st of March. And prior to this, Lordship may just see a Lordship order which is also annexed here. Kindly come to this application. We have also next all these subsequent extensions have been called. Kindly come to this application, page number 49 of volume 1. एक बार दिखा
This is for the suit. This order was for the suit. Who is your other side?
normally, we don't serve before the
Yes, this is it.
See, this is the new application for contempt. So unless Lordship issues a rule, it will serve thereafter.
Yes, this is yes.
No, this is a CC contempt petition. This is not in.
I will not issue rule right now. Let me check
page
it.
49 of your Lordship last.
Come on the next week. Let me check it.
Only one thing, Lordship order we have annexed by this court, page 49, volume 1. Can you go through the order once? Because all these subsequent orders have been passed. We have annexed one of those orders.
Page 49.
49, volume 1, 30th January 2025. And here, Lordship, the Lordship has noticed that in page number 50. Kindly come to the next page. GS6. Next page, page 50.
Okay, I will check it.
GS6 is
all right. I will check it. Come on the next date.
The item number 10 is also there, in which this order was passed, which is under contempt. So when Lordship takes item number 10, we are here. We can again come. This GS6 was where this.
GS 23 of 2016 along with CC 30 of 2025 is adjourned to.
The interim expiring on
31st
March this month. Kindly extend the interim order. I've handed over the copy of the last order, which will show that it is expiring on 31st March. A copy extra. Kindly see the order of 20th February.
27th March. 27th, I will accommodate testamentary matters.
Yeah, that's a lot
First
of
up.
usual day. 27th.
Come on the date.
For item number 3.
3 and 10.
10 also.
Both.
But 10 malas, they were appearing. Item number 10, the GS, other side was
Come on the next date.
inform.
Let the other side come, I will tell them.
No, we will inform. Lordship need not be worried.
Next date.
For arguments, item number 4.
Yes, sir. Sir, what I found in this case, no issues are there. Issues are to be framed. Since caveat is not discharged, caveat are not appearing, they are not discharged. But that is not discharged. There is no order of discharge of caveat. Let the issues be framed since WS is there. Because issues will be very stereotype issues.
They are not appearing.
Right, but there is adduced evidence.
They have not adduced evidence.
Cross-examine possibly.
No, none of them appears.
Anyway, since a written statement is there, they get to be at a, I think cross-examinations were there. There was a written statement at least.
There is a written statement.
And the suit was not ex parte, undefended.
But if they are not appearing at the hearing.
No order of undefended suit. Issues may be framed. This is nothing serious.
In a testamentary matter, the only issue is whether the will is attested or.
No. They have alleged fraud. That's why issues are to be framed. Fraud or manufacture or something like that. That issue is to be framed and to check whether evidence is adduced to discharge the burden of proof. If no evidence, then that will be the order.
As a matter of fact, in my written notes, I have indicated that nobody has appeared.
এটা কি দিয়েছো? আমি চাইলাম সাক্ষীটা।
Don't you sleep on. There are 3 persons who have admitted. One is routine.
Now, after 49, any other questions were put? Because after 49, I see adjourned till 11th November. Check it.
The Lordship is looking into
Ranjushree Pal.
Ranjushree Pal.
No, cross-examination was there.
Cross-examination,
Rotin Shaha.
Rutin Shah.
No, sorry. Yes.
I had
You-
no.
Rotin Shah was cross-examined. He was cross-examined.
He was cross-examined.
So that's why it should be there. But you check it whether further questions were asked or not. Adjourned till 11th November, that is mentioned. See question number 49.
Ronju Sripal, 44, 49,
Was there any, because it was adjourned, not closed.
adjourned till 11th November.
What is the order of 11th November? Check karo to.
11th November. Forty-nine of the page and Ronju Sripal.
এরপর 11th নভেম্বরের অর্ডারটা কি হলো?
November, I don't think there is any.
Then whether further examination in chief was there or not?
No,
This
there
is the
are-
last question.
49 is the last question.
Supposed to be.
Yes. They never came to cross-examine her.
Ranjushree Pal was DW2.
Three.
No, there was closure. In terms of order dated 19 December, cross-examination was closed.
49.
11th November, it was fixed. But
Nobody appeared.
nobody appeared. Then it was taken up on 3rd December.
There also nobody appeared.
No, you appeared.
I appeared, but there nobody appeared on behalf.
Subsequently, it was cross-examination was closed. 12th December, it was taken up. Notice was given. None appeared. So cross-examination was closed. But it is not undefended suit.
As a matter of fact, after the will was tendered as Exhibit J, they disappeared from the scene.
All right, I will frame issues. I am fixing a short date. Check the issues. I will reserve it for judgment.
Yes, my lord, and I have already filed my written notes of.
Yes. And if I have any clarification, I will put it.
Certainly, my lord.
এটাকে দিয়ে দিও চেম্বার, আমি ইস্যু ফ্রেম করে দেবো। নেক্সট ডেটটা হচ্ছে, এটাকে করে দাও। আমাদের টেস্টামেন্টারি কবে আছে? আর্গুমেন্টেই তো থাকবে, সোমবার করে দিচ্ছি। 21st March, Friday.
Your lordship pleasure to fix it for judgment or for.
No. You check the issue. I'm not reserving it. No, I'm not find it. I'm not able to find it.
I have also not found it in my.
Should be.
Should be.
When there are two pleadings, rival pleadings are there must be issues.
For your lordship's convenience, may I bring suggested issues?
I have already framed certain issues. If these are very stereotype issues, I'll just put it.
Witness action. Item number 5.
Application taken out by the plaintiff, my lord, for examination of the witness on commission through video conference, I would like to use an affidavit. My lord, 2 witnesses have already been examined. The third witness, my lord, got to be examined on commission through video conference. Kindly permits me a fortnight's time to file my affidavit in opposition, my lord. There is no.
Why you want to oppose it?
But I am opposing this, my lord, because of few things, my lord. Number one, my lord, it has been shown that the person who's supposed to come and give evidence is so busy that he cannot come before the court. I have an objection to that. Number one, my lord. Number
You
two, my
cannot
lord,
say anything on personal life.
my
He
lord,
may be busy, he may not be busy.
this person has not affirmed this application, my lord. Application has been affirmed by someone else. Second, my lord, they have not said that whether they are going to use documentary evidence.
What
or not.
prejudice will it cause to you?
My lord, I'll tell
Give you 7 days time, come with your affidavit.
my lord, yes, my lord, I'll come within 7 days.
GA 3 of 25 is filed by the plaintiff praying for examination of witness by way of video conference. Full stop. The learned counsel for the defendant oppose the application and prays for to file affidavit in opposition. Opportunity is given till the returnable date, that is 25th March, to file affidavit in opposition.
My
The
lord, I
matter
must
will appear in
also
the list.
indicate to my learned friend also that it is not indicated in the application whether they want to mark any new documents and exhibits. Because the
Come with you.
witness
I
will
am
be-
giving you opportunity. Come with that.
Very well. I'm extremely
The matter will appear in the list on 25th March.
I'm extremely grateful.
My lord, any affidavit in reply I need to.
Let him file.
27 Item number 6.
Item 6, I'm appearing for the plaintiff. Yesterday, Mr. Banerjee had mentioned the matter because the witness who is supposed to be examined has some urgency and is out of India.
When you like to bring your witness,
He is come as instruction. I'm submitting that he'll be back on 28th or 29th of this month.
did bolo.
9 between 9 to 12. 9 to 12.
On prayer of the learned counsel for the plaintiff, witness action is your plaintiff adjourned to 10th April.
I'm grateful, Lordship.
7.
Lord, I am for the plaintiff. My witness is here for cross-examination.
Where is your witness? Who is the other side?
Mr. Kothari.
But I think I noticed one thing. Too much holy is not good.
Yes, I have seen just now. I also marked Mr. Kothari. He had played a lot, but without treating us.
First holy after marriage, you're forced to play.
Yeah, that I could make out. That is why I said without treating us.
Piyush Vaid.
Bijus. First title of that one.
May I have my lord's sleep? My junior is here.
How do you know Mr. Kamlesh Agarwal?
He is a friend to my father.
Why did you lend money to Mr. Kamlesh Agarwal?
He was in urgent need of funds for personal reasons, I believe.
So the loan was given to the defendant for his personal need.
Yes.
Shown Exhibit A.
You are cross-examining.
Yes, Your Lordship.
This is a case of money lent. Say no. The same earlier one.
In the nature, Your Lordship. Unfortunately or unfortunately, I'm always for the defendant. Shown Exhibit A. Does this letter dated 18th of August 2017 mention the words intercorporate deposit?
Yes.
Do you know what does an intercorporate deposit mean?
I'm not very sure about these certain terms used here. Intercorporate deposit.
When did Mr. Kamlesh Agarwal asks for money from you?
It is mentioned here in this exhibit as shown by you.
Can you?
18th of August 2017.
Did you have the occasion to meet the defendant at that point of time?
No.
Shown Exhibit G. Can you tell what is this letter about?
ইস্যু ফ্রেম করতে হবে, রেকর্ডটা পাঠিয়ে পাল চৌধুরী এটা। আর এইটা কজ লিস্টে পাঠিয়ে আমি ডেটটা লিখে রেখেছি, ওটা আমি নিজেতে বলবো। ওকে, নেক্সট ডেটটা দিয়ে দিতে হবে। ইস্যু আমার করা আছে। হাতের উপর
Yes.
ইস্যু দিয়ে করা হয়ে গেছে। ওই ইস্যুটাকে কপি
This is the notice sent by my advocate, LP Manot and Company, to Mr. Kamlesh Agarwal.
Witness, please go slow so that your answer can go down.
LP Manot and Company, and it was addressed to Mr. Kamlesh Agarwal. Mr. Kamlesh Agarwal.
Do you find the words intercorporate accommodation loan in this letter as well?
Yes.
I suggest to you that the loan advanced by the plaintiff to the defendant was for commercial purposes and not for the personal need of the defendant. This is a suggestion. You can either agree or disagree and then say whatever you want to.
It was a personal arrangement to grant money to Mr. Kamlesh Agarwal, the use of which was not known to us. The use of which was not known
What is
to us.
intercorporate deposit?
My lord, I am not very sure about what the term intercorporate accommodation.
Then why did you advance money?
My lord, he was my father's friend, and I was suggested by my father to grant the sum because he was in need of money at that time and at that point in time.
On which date this money was given to him?
My lord, 18th August 2017.
How it was given?
By an RTGS issued by my bank, Kotak Mahindra.
Yes.
Which may I come back? I've completed 2 issues. Next occasion, I'll probably complete
DW1 or PW1?
PW1.
PW1 is partly cross-examined. Further cross-examination is deferred to. April 7th.
My lord, I will be traveling from 27th March to 8th of April. So if we can we can schedule it accordingly.
Any day after that.
24th April? 24th April.
Grateful.
Thank you. Thank you, my lord.
Testamentary matters. Item number 8. Praveen Kumar Das.
This GA3 is for sale of property.
GA3, the supplementary affidavit was for sale of property, but GA3 was for removal of the administrator, my lord.
Supplementary affidavit is order is yet to be passed or passed.
That has been passed, my lord. The only thing, there has been some typographical errors.
Give it.
I have made the proposed corrections if my lord does not.
Hand it over. Put it in order. So when GA3 is fixed for hearing?
Today it was fixed for hearing, my lord.
Make the corrections. Let the corrections be made out first. Now here you are praying for?
It's not my application, it is their application for.
Focus is appearing in this matter. He's coming in that step.
Come some other day. Let the corrections be made today. Following corrections are made in the order dated? They can
March 2025, my lord.
6 March 2025. Let the application appear in the list on April 1st.
Item number 9.
Well, this is my application. On 13th of February 2025,
What is GA2?
well, there was a deduction to issuance of general citation, my lord. But up to today, my lord, 18th of March, my lord, we are seeking some more time. Kindly extend the time at least for 1 month.
On prayer of the learned counsel for the petitioner, time is extended for issue of citations till 20th May.
Grateful, my lord.
11.
Yes.
Item number 11, Mr. Kormakar is appearing. He is engaged in code number 18. May I just pass?
Today is fixed for what? GA6 and GA7.
GS6 and GS7.
Yes. Oh, sorry. That is an earlier one.
My lord,
what is the status of the suit?
In this matter, issues are framed, and it was supposed to be appeared as
for witness action. Mr. Chaudhary, you are in which matter? You have missed the train.
Standing on the platform.
I have adjourned it. Item 10. Yes, some corrections are to be made. Let the corrections be made.
They will thereafter be heard, you know.
Yes.
Because the prayer in the supplementary, your lordship has not.
Then it is to be seen whether he is to be removed or not.
That's the main point.
So, 1st April. Not to befool you. Take it for granted. We'll start hearing.
But it's supposed to be appeared as witness action.
When will you be able to bring your witness?
But
When will you be able to bring your witness? Or would you examine on commission?
no, my lord, he's able to come.
নেক্সট সাক্ষী দিতে হবে, কবে সাক্ষী দিতে আসবেন? সাক্ষী তো দেওয়া হলো না, সাক্ষীর জন্য তো ফিক্স করতে হবে, সাক্ষী তো দিতে হবে, কবে আসতে পারবেন? আপনার পক্ষে সুবিধা কখন হবে বলুন?
স্যার আজকে হবে না?
আজকে where is your other side? He is not here. And it is not fit for witness action today itself.
My lord, after a week.
That's why I am speaking of appointment of commission.
My lord,
Because one day will not be enough. He will have to come 2 or 3 days. For cross-examination will be there. So it can be 2 or 3 days. Fixing it on 25th April, coming Tuesday.
Right.
Check it whether you need an appointment of commissioner.
Right.
That will save court's time. That will be save him from coming, save him from O's
Right.
for coming to the court.
Right.
The suit will appear in the list for witness action on 25th March. আপনি ব্যাপারটা বুঝিয়ে বলুন। Please explain the matter. Appointment of commission.